Are we ready in Springfield and Chicago?
Maybe even the year after that, really went.
It's still wonderful.
Oh, yes, but you know what I mean. Like,
We're ready in Springfield. Did you hear us, Madam Chair?
Yes, I did. Thank you, Madam Vice Chair.
Laura? Yes.
You'll have Chris's prophecy.
Oh,
Good morning, everyone, and welcome to the January 22nd, 2025 meeting of the State Board of Elections. May you all stand at this time for the Pledge of Allegiance. I pledge
Allegiance to the
to
flag,
the flag
United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please, Mrs. Calvin.
Ms. Ballard Croft. Present. Ms. Craig. Ms.
Yep.
Genovese.
here.
Ms. McCory.
Present.
Mr. Turbin.
Present.
Mr. Brett.
Present.
Vice Chair Donahue.
Present.
Chair Watson.
Present. Is there a motion for the approval of the minutes of the November 19th and December 2nd board meetings?
So moved.
Second.
Roll call, please, Mrs. Calvin.
Ms. Ballard Croft.
Yes.
Ms. Craig.
Yes.
Ms. Genovese.
Yes.
Ms. McCory.
Yes.
Mr. Turbin.
Yes.
Mr. Brett.
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes.
Motion passes.
Thank you, Mrs. Calvin. We continue with the report of the General Counsel. Madam General Counsel, please.
Good morning, everyone. We'll start our campaign disclosure report today with settlement offers. I'll first call agenda item 2A1 SBE versus campaign to elect Dave Bartley, 22 and F008. I understand there is someone present on behalf of the committee, either in Chicago or Springfield.
Springfield.
Okay, excellent. So whoever is here, I will read my recommendation first, and then the committee will have the opportunity to address the board. The committee is offering $126 to settle $9,000 in fines for late filing of the December 2021, March 2022, and June 2022 quarterly reports. That is 1.4% of the outstanding fine amount. The offer is compliant in terms of balance and receipt ratios, and the committee is considered low dollar. The committee also filed a final report earlier this month showing it closed in August 2023. The $126 offered appears to be the committee's remaining funds, but the final report already showed a non-itemized expenditure of $126 to bring the balance to $0. I recommend accepting the offer of this closed low dollar committee as it comports with settlement guidelines. And is someone present from the committee in Springfield?
Yes, ma'am. We have Mr. Bartley here.
Yes.
Pass.
Oh.
Be sure to speak up too, please.
Okay.
There you go.
I would just say I concur with your recommendation.
Mr. Bartley, would you please state your name and spell your last name for the record?
David Bartley, Bartley.
And who are you with and representing at this time?
Campaign to elect Dave Bartley.
You may proceed.
Madam Chair, he accepts the offer or the resolution. And so I would move that we accept the settlement offer for 2A1.
So moved.
Is
Second.
there a second? Roll call, please, Mrs. Calvin.
Ms. Ballard Croft.
Yes.
Ms. Craig.
Yes.
Ms. Genovese.
Yes.
Ms. McCory.
Yes.
Mr. Turbin.
Yes.
Mr. Brett.
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes.
Motion passes.
Thank you,
you.
Mrs. Calvin. You may proceed, Madam General Counsel.
Thank you, Madam Chair. The next matter is agenda item 2A2 SBE versus Deirdre Bowman for Judge 24 MQ 31. I understand Judge Bowman may be running a bit late. Has the judge arrived in Springfield?
No, ma'am.
She's, her part
Yeah, it says Chicago.
was
Oh,
Chicago.
it says Chicago. Okay, my apologies. Well, let's skip over her for a few moments if that's okay.
That's
Proceed,
quite all
Madam
right.
General Counsel.
Okay, the remaining two settlement offers are, is there anyone here on agenda items 2A3 or 2A4, our remaining settlement offers?
Not in Springfield, madam.
Okay, and not in Chicago. So for agenda items 2A3 and 2A4, the recommendation is to accept the offers because these committees are low dollar.
I would move to accept the recommendation of the general counsel on 2A3 and 2A4.
Second.
Roll call, please, Mrs. Calvin.
Ms. Bellarcroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Madam Chair,
Mrs.
Madam General
Calvin.
Counsel, we have in Springfield, people present for 2A7. If you would like, they are here and present.
Great, thank you for letting me know.
Madam General Counsel.
Moving into appeals of campaign disclosure fines. I'm gonna call first agenda item 2A5. Is anyone here on agenda item 2A5, SBE versus Kane County Republican Central Committee?
Not in Springfield.
Okay, the recommendation here is to grant the appeal and order the committee to amend the relevant quarterly reports. I also wanted to point out there's a small error in the hearing officer's report in which the hearing officer mistakenly refers to Calumet Township instead of Campton Township. It ought to read Campton Township. And again, the recommendation of the hearing officer, with which I agree, is to grant and order an amendment.
I
There a
would move,
motion?
yes, I would move that we accept the recommendation of the general counsel with the change in the name of the committee for 2A5.
Second.
Roll call, please, Mrs. Calvin.
Ms. Bellarcroft,
Yes.
Ms. Craig. Laura.
Yes.
Ms. Genovese, Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes.
Motion passes.
Thank you, Mrs. Calvin. Madam General Counsel.
Thank you. I'm going to move back to agenda item 2A2, SBE versus Deirdre Bauman for Judge 24 MQ 31. Ma'am, if you would like to step up, or Judge, I should say, Your Honor, step up to where that green light is. I realize it's a little bit hard to see. That's where the microphone is so that they'll be able to hear you. Sorry, it's almost impossible to see. I will read my recommendation and then you'll have an opportunity to address the board. The committee is offering $1,500 to settle $16,450 in fines for late filing of a total of 6 A1 reports during the second and third quarters of 2023, as well as the March 2024 quarterly report. This offer is 9.12% of the fines owed. Here, the committee has an average ending balance of $617.32 and is therefore considered low dollar. The offer is also compliant in terms of balance and receipt ratios. Therefore, I recommend accepting the offer of this low dollar committee as it comports with settlement guidelines.
Would you identify yourself, Your Honor, for the record?
Not Your Honor, not yet.
My apologies.
No, it's fine, I love it.
Better to assume
Yes.
than to get it wrong.
Deirdre Bauman. And I appreciate the recommendation. I did submit my name for the board for the Triton Community College District. And I know I had asked for 45 days to pay this. I don't know if that's possible or whether I need to pay, assuming the board accepts graciously the recommendation, or if I would need to pay it today.
So normally, we ask that offers be paid within 30 days, but the board does have the discretion to increase that time to 45 days if the board so chooses.
I'm sorry, 30 days would be absolutely fine. I know there's a rule, though, that I cannot appear on the ballot unless the fines are paid. For the ballot for the March 1st election.
So any ballot forfeiture for the March 1st election would have already taken place, but I don't know whether you were on that list. Is our director of campaign
Yes.
disclosure, Tom Newman, here?
Tom's here.
So, yeah, let me offer a quick correction. First of all, it's the April 1st ballot, for which the
I
ballot.
apologize.
That's all right. The certification date for that is tomorrow, so the fine would need to be paid today if her name is going to appear on the ballot.
Okay, thank you, Tom, for that clarification.
Okay, thank you.
I would move that we accept the recommendation of our general counsel and that the fine be paid today so you can go on the ballot.
Second.
Roll call, please.
Ms. Bellercroft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Thank you, Mrs. Calvin.
Thank you very much.
Madam General Counsel.
Thank you. Moving on to an appeal of campaign disclosure fines in which the hearing officer recommended granting the appeal in part and denying it in part. That is agenda item 2A6, SBE versus Friends of Joseph E. Mercado. Is anyone here in Springfield or in Chicago on that matter?
No, ma'am.
Okay, thank you. The recommendation here is that I agree with the hearing officer that the appeal should be granted as to the fourth contribution, which was accidentally misdated, and the associated $2,400 fine vacated. So if this recommendation is adopted, the committee will still owe $1,110 in fines from the first 3 violations for which the appeal would be denied.
Any questions? Is there a motion to accept?
Madam
Yes,
Chair, I
we
would
will.
move that we accept the recommendations of our general counsel for 2A6.
Second.
Roll call, please, Mrs. Calvin.
Ms. Bellercroft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Thank you, Mrs. Calvin. Madam General Counsel.
Thank you. Moving into appeals of campaign disclosure fines where the hearing officer has recommended a denial of the appeal. I am going to call first committees that have filed an appearance with the board today. So the first is agenda item 2A7, SBE versus Ogle County Republican Central Committee, 24 AM 12. I see there is a representative of the committee here. Sir, I will read my report and recommendation, and then you'll have an opportunity to address the board. This committee is appealing a total of $5,778 in civil penalty assessments for late disclosure of 4 A1s filed on April 9th, 2024. The contributions totaled $6,779.48 and were disclosed between 16 and 57 days late. The committee also has a previously stayed penalty in the amount of $500 for late filing of the September 2023 quarterly report for a total of $6,278 in fines. The committee's treasurer said he was not aware that contributions of $1,000 or more needed to be disclosed within days of receipt. The committee also asked that the fine be reduced because the errors were inadvertent and corrected when discovered, which is something I would recommend handling separately through the board's settlement process. Here, I agree with the hearing officer recommendation that the appeal should be denied for lack of a statutory basis.
Madam Chair? we,
Yes,
We have two representatives here from Ogle County.
would
Good
you
morning.
ask them to identify themselves for the record, please?
Yes, Madam Chair, my name is Michael Coolidge. I'm the chairman of Ogle County Republican Party. And I have with me,
Yes, and my name is Kevin Colbert. I am the treasurer of Ogle County Republican Central Committee.
Thank you, gentlemen.
yes, and my last name is spelled with a K. It's Koolide.
You may proceed.
Thank you, Madam Chair and members of the board. I am Michael Coolidge, as we stated. Thank you for the opportunity to present our appeal regarding the untimely reporting of contributions exceeding $1,000. We deeply respect the board's critical role in maintaining transparency and fairness in campaign finance. This board has established a fair and principled policy to stay first-time violations when no subsequent violations occur. This policy exists because the law and procedures guiding your decisions recognize that first-time offenses often result from unintentional misunderstandings, not willful misconduct. And our case aligns with this rationale, we believe. And I respectfully ask that you consider the factors laid out in both the statutory basis and in your established procedures. The first point, the statutory basis designed to recognize good faith. The hearing officer's recommendation says that there is no statutory basis for our appeal, but we respectfully disagree. We explicitly cited 10 ILCS 5, 9 through 10G, which requires the board to consider factors designed to distinguish honest mistakes, which is what we made, from intentional or negligent violations. And we believe this conclusion disregards the clear intent of the statute to ensure fairness and proportionality in cases like ours. These factors include, number one, efforts to disclose contributions. We consistently disclosed all contributions in our quarterly reports with no attempts to conceal or misrepresent activity. Inadvertence, the hearing officer himself acknowledged, quote, there is no reason to doubt these were unintentional oversights by the committee, which they were. Number three, clerical error. Our misunderstanding stemmed from a procedural error. Historically, our committee used the IDIS system quarterly, which was appropriate for our smaller activity levels. When larger contributions began arriving, this process became insufficient. We did not know what reports were required, these D1s, until we were notified in April of 2024. And this violation occurred from a August of 2023 contribution. And number four, history of prior violations. This was our first time receiving contributions exceeding $1,000. Definitely while we were in charge of the organization, and as far as we know, during the entire history of the organization, to our knowledge, has never had a contribution over $1,000. So this was not some information that was passed down to us that we needed to do this. These factors demonstrate that our violations were unintentional, transparent, and promptly corrected, meeting every standard under the statute for factors the quote board shall consider for leniency and stated in the aforementioned 5.9-10G. Our second point, procedural basis shall consider factors. The board's rules in Title 26 Elections, Chapter 1, Part 125, Practice and Procedure reinforce these statutory principles. Section 125.425 specifically requires the board to consider such factors as history, cooperation, and mitigating circumstances, all of which we believe support leniency in our case. The party's history, as stated, we have no history of prior violation, acted transparently in all filings. The ignorance of the rules, the hearing officer confirmed our lack of awareness of the A1 requirement and even request sympathy for the 8-month delay in notifying us of that first violation. And three, cooperation. We fully cooperated with the board, participating in hearings and provided documentation in good faith. And four, factors in mitigation. Upon notification in April of 2024 of the August 2023 contribution, we immediately updated our procedures to ensure daily IDIS monitoring, reflecting a swift and sincere commitment to compliance. And our final point, our final point, policy of staying first-time violations. We respect the institutional practice and processes laid out for this necessary work and would like to appeal what we see as the intent of that established practice and procedure. The purpose of the board's policy to stay first-time violations is to account for the reality that many first-time violations stem from a lack of knowledge. In our case, the additional violations occurred before we were made aware of the A1 requirement. We were made aware in April of 2024. The subsequent violations occurred in January, February, and March of 2024. And the notification was in April of 2024 for the August 2023 violation. In our case, the violations occurred before we were made aware of the A1 requirement, meaning they all stem from the same initial misunderstanding. Treating these as separate offenses creates a distinction without a meaningful difference and undermines the intent, we believe, of the board's policy. So in conclusion, members of the board, we believe our case is clear. Our violations were unintentional, promptly corrected, and resulted from a misunderstanding, not negligence or misconduct. Number two, both the statutes and procedural rules guiding your decision support leniency in situations like ours. And number three, the rationale behind the board's policy for first-time offenses applies directly to our case, as subsequent violations were the result of the same unintentional misunderstanding. In conclusion, the whole of our argument is this: we respect your role and authority to delineate and judge, essentially, the clear distinction between two different types of violations: negligence or malfeasance, which certainly did not apply in our case, or ignorance and unintentional violations with goodwill, which did in our case. So we therefore respectfully ask the board to grant leniency in recognition of our good faith, transparency, and sincere commitment to compliance going forward. Thank you.
I have a question, Madam Chair.
Yes.
Thank you. That was well argued. It was very persuasive. I have a challenge understanding why what you described is not negligence, specifically because all the other committees that exist in the state of Illinois are aware of the A1 requirement. It just because.
Can you
were
speak
not
up,
aware.
Member Brett?
Yes. Could you please explain why what you described is specifically not negligence? All the other committees that are formed and operated within the state of Illinois are aware of the A1 requirement, and normally not knowing simply not following the rule is not considered an honest mistake. All the other committees know of this rule and comply with it. It was well argued what you said, but you, to be clear, have not persuaded me that what you described is not negligence.
Yes, I would like to speak to that. This is Kevin Colbert. We're referring to what's available in statute and under the practices and procedures regarding the reasons why you would give us leniency. And they refer to such things as ignorance of material facts and other good intents. So we would not be negligent under this in the sense that you actually offer the leniency for first-time offenses. And truly, if we had another offense, we would be negligent, because now we would be not implementing the practices and procedures necessary to do what we have been proven to be known to be not done. Now, in the sense that there would be negligence, it would be something that would be truly judged based on the reality that this information is available. If we had studied it in the statutes, we would have known. But in reality, we as an organization depended on the institutional memory that we had. And that institutional memory did not include such things as this. That's another thing that we did. We updated our practices and procedures, and we'll hand down this institutional memory to future holders of these offices. That would be not negligent if we did that in the future. If we did fail in the future, that would prove negligence.
Question, Chair. Mr. Colbert, how do you explain that this was your first time offense when you had an offense back in September of 2023 and that fine was stayed? So clearly the actions that happened in 2024 was not your first offense.
That's a great question. And the point is that we were not made aware of that offense until after the subsequent failures. And so this is something that happened because we did it the same way we did the ones in 2023, the one that was a failure in 2023. And we didn't know about that failure until we were notified of it. And there were
In
subsequent
April-
failures
In April of 2024. That's the first time we were notified of that violation.
But I still stand by Mr. Vett's argument that ignorance of this statute is not an excuse. Every other committee, as he has said, has followed the A1 filing. So
Right.
I'm gonna
Well-
make a motion to accept the recommendation of the general counsels
Done.
and deny the appeal.
Second.
Second.
Roll call, please. Mrs. Calvin?
Chair, wait a minute. We have a question down here, please.
Yes. Is there a question?
Thank you very much. And I'm kind of like what you guys were saying. I think that you did a very good job of explaining some things, but what confused me was that you said you were not aware of making this type of a filing until you moved from the small cap basically to a larger program, which required it. Now you're saying that you didn't get notified enough in time and it was already done and the infraction was already done when you got fined the $500?
No, so we received a contribution August 2023 event for $1,500. That's the first time we'd ever received a thing over $1,000. Nothing triggered in our minds, oh, we got to do the D1 report right away. It was, oh, great. We will just file this at the quarterly report like we normally do. We were very thankful for that $1,500 contribution. And we filed that report on time and that's on there. We didn't we didn't hide that anywhere. That violation, we didn't get anything in the mail or weren't notified that we should have filed a D1 until A1, I'm sorry, until April of 2024. And then we panicked because we were made, oh shoot, we were supposed to do that. We didn't know. And then we look back, oh my gosh, we got another one in January and February and March. So we're like, oh gosh, we're going to get nailed for those too. But we didn't get that, oh my gosh, we violated a rule until April of 2024.
And this speaks directly to, if I may add, the Title 26 Elections, Chapter 1, State Board of Elections, Part 125, Practice and Procedure, D or E3 or E2, any evidence of respondents' ignorance of material facts that leads to the conduct. So this is our argument, is that we were ignorant of it. And I think that speaks also to your policy of having first-time violations stayed for that purpose. And I think that a purpose actually applies to our situation because of that evidence of ignorance of the facts.
If I may, I know that a motion has been made and that we're going to proceed to voting, but you have not persuaded me because you're not talking about a mistake of material fact. You're talking about a misunderstanding and the lack of knowledge of the law. And the argument, if we accept it, in my opinion, would mean that this board would have to say as a rule that we will not enforce the rules against any committee until they have effectively broke it one time and then we have notified them of the violation. And now they're officially notified of it. The clearer rule that's more transparent and it is uniformly applied is that once you're a committee, you are the officers that are in the responsible positions of that committee are stating that they are aware of the rules, or if they're not aware of the rules, that they will become aware of the rules and comply with it. Therefore, I think that the time for argument is closed and I'd like to move forward with the voting on the motion that's been seconded.
Can I ask one quick question? Excuse me, member.
Madam Vice Chair?
Marnie, you said something at the end of your comments that we had some discretion and on something. What are you referring to?
So normally, the provision of the election code, section 9-10, that talks about reducing fines is something that the board has implemented through Rule 125.450, settlement of civil penalty assessments. The standard is different for an appeal. For an appeal, which is under Rule 125.425, the standard is whether there was error in the assessment itself. So if the board, or excuse me, if the committee wanted to make a settlement offer, the board could consider reducing the fine. But the appeal process is not the venue to do that or the vehicle through which to do that.
What
Member
would,
Bragg? I'm sorry, Madam Vice Chair.
I was just going to ask Tom what what are the parameters of an offer?
Well, they would have to go through the settlement process and that starts after we make our ruling.
Okay, so,
Do this first. Okay. So it's just, hopefully I can speak. I'm just
Excuse
trying to
me, Member
Hang on.
Rhett. Member Rhett, do you have any
Yes.
comments?
No, I have no further comments. I think someone else is speaking. It just sounds like me.
Yeah, that I'm flattered. What I was just gonna ask for clarification on is that, so if it is decided that that the board here agrees with the recommendation and we're fined the full amount, we can appeal that amount. We can't appeal the ruling, but we can appeal the amount. Is that accurate?
No, that's not accurate. You can make a
Okay.
settlement offer, which the board can then consider.
Okay, and when can we make that settlement offer?
I would suggest getting together with Tom Newman, the Director of Campaign Disclosure, after this meeting, or giving him a call at some point, and he can walk you through that process.
Great, thank you.
Madam Chair, I think we're completed down here.
Anything further from the members? Please continue the roll call, Mrs. Calvin.
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Genovese, Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes,
Motion passes.
thank you, Mrs. Calvin.
Thank you.
Madam General Counsel.
Thank you, Madam Chair. The next case for which I have an appearance on file is Agenda Item 2A15, SBE versus Friends of Tiffany Henyard, 24 JQ 111. If any representatives of the committee could step up, there's a green light up there in front of the board. It's very hard to see, I realize, but that is where the microphone is. If the board wants to kind of direct you in that direction.
Right in front of me.
Great, thanks, ma'am. I am going to read my recommendation and then you'll have an opportunity to address the board.
Thank you.
The committee is appealing a $1,000 civil penalty assessment for the 50-day late filing of the June 2024 quarterly report. The committee has a stayed fine of $500 for delinquent filing of the March 2023 quarterly report. The total for both pending assessments is $1,500. Attorney Max Solomon appeared for the committee at the appeal hearing and explained that the person with the committee's IDAS login information left the committee without sharing the login information. Mr. Solomon personally helped the committee to reset the IDAS system and obtain login information in order to ultimately file the report. However, that the person with the login credentials left the committee is not a recognized offense. Even if the committee here tried to invoke an electronic filing defense, Rule 100.150C5D provides that misplacing, forgetting, or simply not knowing a username or password shall not constitute a valid electronic filing defense. I therefore agree with the hearing officer that the appeal should be denied for lack of an adequate defense and $1,500 would be owed.
Would you please state your name and spell your last name for the record?
Tiffany Henyard, Henyard.
I'm sorry?
Tiffany Henyard, Henyard.
You come to speak under it. We don't have that great on media systems.
That's why I shout.
You may proceed.
All right, I'm asking to have it waived. I've never been late. I never not filed any of my documents. Someone handled that for me, and unfortunately, the person is no longer with me. Basically, Max Solomon is the one that's handling it now, and I've been current ever since. I've never been late, ever. So I'm asking you guys to at least take that in consideration for first time, I guess, not filing for, you said 50 days. If I can have it waived, I will greatly appreciate it.
What is the $500 stay? What is that about?
$500 was for delinquent filing of the March 2023 quarterly report.
Is that your committee?
My committee is Friends of Tiffany Henyard, yes.
So you had a violation previously?
Previously, not that I know of, I just know of the violation that was sent to me and it said I owe $1,500.
Madam General Counsel, the $500 stay, is that the same committee?
Yes, that is the same committee. I can point you to, in your packet, page 102, which shows the $1,000 fine being assessed. It also lists the previous fine amount of $500 for a total of $1,500.
And Ms. Henyard, you're saying you don't have any knowledge of this?
That's correct. Someone always handled my committee, I never handled it. Her name was Barb, she did get sick and ill. And that's why we, at this stage, I had to find someone else. Max Solomon is the one that files my quarterly reports currently. So lately I've been on track, on time, no issues. It's the first time I ever had a fine. So that's why I'm before you now.
Well, you've
Mr.
got
Newman, how much is in this fund?
The average ending balance that was last reported was $70,076.54.
Any other questions, members?
No, I sympathize with your position, but it does appear that the committee that you represent is fine. And therefore that would be the time for this stay. And unfortunately we have to proceed with the rules as follows from there. So just because you did not have knowledge, you did have a representative of the committee, and it appears that perhaps that individual handled that on your behalf. So I just want to make clear for that we will proceed, I think, with a motion, but this is based on the fact that there is in fact a prior violation that was stayed. So with that, I move that we accept the general counsel's recommendation, lift the stay and deny the appeal.
Second.
Roll call, please, Mrs. Calvin.
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Mr. Nevesi,
Yeah.
Ms. McCrory,
Yes.
Mr.
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson,
Yes.
motion passes.
So what your process now is to make a settlement offer.
Okay, how that work?
If you'd like to talk with Andy Nauman back there in the corner, he's our Assistant Director of Campaign Disclosure, and he can explain that process to you.
You may proceed, Madam General Counsel.
Thank you, Madam Chair. The next item for which we have an appearance, agenda item 2A16, SBE versus Friends of Gina Meeks, 24 AM1. I believe we have someone here, and ma'am, if you'd like to stand by the green light, that's difficult to see. Thank you. I will read my recommendation and you'll have an opportunity to address the board. The committee is appealing $6,000 in civil penalty assessments for late filing of the September and December 2023 quarterly reports, as well as the March and June 2024 quarterly reports. The 4 late reports were filed between 27 and 210 days late. The candidate said she believed she was only required to file quarterly reports in periods with activity, and she also provided documentation of the committee's lack of activity during these periods. The candidate also said she had health issues and that the committee cannot afford the fine, which I would suggest handling through the settlement process. Here, I agree with the hearing officer recommendation to deny the appeal for lack of a statutory basis, and $6,000 would be owed.
Would you please state your name and spell your last name for the record?
Sure. My name is Gina Meeks, Meeks.
You may proceed.
Thank you so much for allowing me to speak. I am a freshman alderman. This was my first time running for office. Prior to me taking office, I had a lot of assistance in this matter. I've always been my own chair, always been my own treasurer. But I did have a lot of help to get this all started and maintained. And running into the situation that I ran into, I am currently a cancer survivor, still going through the scanning process, triple negative breast cancer, 3C, which caused me to have some of the highest treatment that there was. I was not focused on this at the time. And this is just a situation that I would love to be able to put past me. It is completely inhibiting me to continue my campaign, because if I have this amount of fines, I have worked very hard to raise money in order to compete with my opponent, and I will be unable to compete if I have a fine of this nature. So I totally understand if I need to go through the settlement process and this is denied. I just want to please ask for some reprieve and just make my case here, because there were significant issues prior to with banking statements in order for me to complete filing. When all of that was done, there was a previous fine that was assessed that I did pay out of my own pocket, taking away from my own family and tuition for my children. But I did pay those funds, and I thought that things were behind me. And pretty much a week after that, I received another letter for the time span that is specifically in the frame of when I was diagnosed with breast cancer, which was July of 2023, all the way up until August, when I reopened my campaign. So I really just would not have thought that the time frame that my campaign was closed would have caused this situation. I kind of thought it would have been a wash when I took care of everything with the $2,500 fine, but it obviously wasn't. And so I understand the situation. I do. I really do understand, but I am begging for some reprieve, because I am the first Black woman to run in the 12th ward and win this race in this demographic. I am someone that is doing a wonderful job, in my opinion, as an alderman, and I would love to continue this work, and this would completely hinder. And I also believe that there is a ballot certification that is at stake right now, because this is not rectified, and I might need to talk to Director Tom Newman about the clarification of that. But these are all things that are hindering me from moving forward, and I would love to be able to move forward. So thank you for hearing me out.
May I ask a question? Ma'am, are you planning to be on the April ballot?
Yes, ma'am.
Okay, and are you on the primary ballot? Okay, Mr. Newman, do you mind checking if there's already a ballot forfeiture issue here?
Thank you.
And how much money does your committee have now?
I have $3,704 claimed in my last filing. And that was
Marnie,
a lot.
I'll take a look and I'll report back to you shortly.
He'll be right back. He's got to go to his computer, Madam Chair.
Madam Chair, if I can say, in the meantime, I would suggest you get some help. That you have somebody help you with your filings now.
I hear you, but can I just say, I hear that a lot. People tell me to get legal help and assistance with this. I cannot afford it. I am one of those candidates that is literally doing this because I want to provide a service to the community. And when it comes to getting help, I had that. I had a lot of labor union support that helped me significantly early. I don't have that support anymore. And so my donations are small dollar donations, friends and family. I'm doing the very
I
best.
understand, maybe you can find a volunteer or something. to
I'm
help you so that
working
you're not in
actively.
this situation. again.
Absolutely. I'm working actively to get someone to volunteer.
We are statutorily bound to accept the recommendation of the general counsels, where we have any sort of discretion or leniency would be in the settlement phase. So, but let's hear what Mr. Newman has to say.
And has Mr. Newman returned, or should we?
No, Madam Chair, I would suggest that we continue with the motion because we can't do anything until it's denied. So then she can talk with Tom.
If I could just point out, though, if there is a ballot forfeiture for April, and she does need to settle, that's something we could handle today to make sure she could get on the ballot. Although if she's on the February ballot, there may already be an issue. That's what we're waiting for Tom
I got
for.
you. I was thinking.
So so one option would be to set this case aside for a few minutes until Tom Newman can sort out the.
Oh, he's back. He's back.
Even better. Thank you.
I'm back, yes. So the outcome today will not affect your status on the April 1st ballot, primarily because there won't be a final order for a couple of days, and the certification date is tomorrow. So she will be clear to be certified to the ballot tomorrow.
Thank you.
Excellent. So
But then it would have to be taken care of before the April. Yeah, all right.
Do you understand?
Yes, ma'am.
answer.
So the issue is not one for April, Tom, correct?
Correct.
Because it's not yet a final order. Okay,
Correct.
so this is not going to be a ballot forfeiture issue for you for this year. However, I think after today, you should reach out to either Mr. Newman or Mr. Nauman. Their names are very similar, who can help you through the settlement process.
Today while I'm here.
If you'd like to reach out to Mr. Nauman, he's right back there.
I make a motion to accept the recommendation of the general counsel and deny the appeal.
Second,
Roll call, please.
Ms. Bellicroft,
Yes.
Ms. Craig,
yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Chair Donahue,
Yes,
Chair Watson,
Yes.
motion passes.
Speak to Mr. Nauman today and he can help you through that settlement.
Thank you so much.
Madam General Counsel.
Thank you, Madam Chair. The next item for which we have an appearance on file is agenda item 2A17, SBE versus Friends of Shannon M. Saul, 24 JQ 125. Is someone here on behalf of that committee?
yes, ma'am.
Yes.
She's in Springfield.
Excellent. So I will read my recommendation and then the representative will have an opportunity to address the board. The committee is appealing a $20 civil penalty assessment for the 2-day late filing of the June 2024 quarterly report. The candidate says she went to the post office to mail the report 72 hours before the filing deadline. Under section 9-10B of the election code, a report that is postmarked 3 days before the due date is considered timely received. Here, the receipt provided shows an anticipated delivery date on the reporting due date of July 15th, 2024. However, the postal receipt shows a mailing date of Saturday, July 13th, only 2 days before the filing deadline. So the committee does not meet the statutory mailing exemption. Therefore, I agree with the hearing officer that the appeal should be denied accordingly. But if this recommendation is accepted, the $20 fine will be stayed as a first violation.
Would you please ask the representative to state their name, spell their last name, and the party they are representing, please?
Good morning. My name is Shannon M. Saul. S is in Sam, Alpha, Alpha Lima.
And who are you representing?
Friends for Shannon Saul, myself.
Please proceed.
Thank you, Madam Chair. I'm an Air Force veteran and I'm not here to appeal this. I understand the rules and the laws and it is my mistake. So I would recommend that Friends of Shannon Saul pay the $20 to clean the slate. I wanted to meet all of you and I appreciate your time and effort. And now you know my face with my name. So thank you very much and I approve the $20, and I would gladly pay that today, and it will never happen again. Thank you.
Thank you. Is there a motion to accept the recommendation?
Something first. Thank you, Ms. Saul. We appreciate that. The upside is that your first fine can be stayed. So you can take that $20 and do some good with it.
Thank you.
But
What do I need to do?
is it correct? that
Madam
if-
Vice Chair?
Is it correct that if something, if heaven forbid, something else happens, then you would owe the $20 if we stay it now?
But yes, if there's a second violation, then that $20 is gonna come back at you.
Super. All right. Is there, I would move that we accept the recommendation or recommendations of the general counsel and for 2A17.
Second.
Roll call, please, Mrs. Calvin.
Ms. Ballard Croft,
Yes.
Ms. Cry,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Turbin,
Yeah.
Mr. Frett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Thank you for.
Yes.
Thank you.
Madam General Counsel.
Thank you. The final appeal for which I have an appearance on file is agenda item 2A18, SBE versus Rob Tatelman for McHenry County Sheriff. Tatelman. Sir, if you'd like to step up to the microphone, which is the green light up there, I will read my recommendation and you'll have an opportunity to address the board. Here, the committee is appealing a $500 civil penalty assessment resulting from an A1 disclosing $2,500 donation dated February 28th, 2024. It was reported 26 days late. The committee is also appealing a $950 assessment for the 19-day late reporting of a $1,000 contribution dated March 11th, 2024. The committee's treasurer stated in his affidavit that an email firewall seems to have blocked notice from his credit card company of some donations received by the committee, further stating he misunderstood information provided by board staff that would have helped him mitigate the consequences of the delinquently filed A1s. He noted his lack of experience in campaign disclosure and said he took over for a treasurer who had unexpectedly resigned subsequent to the violation and asked for a waiver of the fines. Here, I agree with the hearing officer that there's been no statutory basis for relief advanced, and therefore I recommend denying the appeal. If this recommendation is accepted, $1,450 will be owed.
Mr. Witness, would you please state your name, spell your last name for the record, and state who you're representing, please?
Yes, good morning. My name is Rob Tatelman. It is Tadelman. And I am representing myself for the committee of Rob Tatelman for McHenry County Sheriff.
You may proceed, Mr. Tatelman.
Thank you, Madam Chair. And thank you, Board. I'm here to talk about, I guess, what Matt Horst, who is my current treasurer of my committee, he is a volunteer. Like all of my committee, he had taken over the treasurer spot. And we use Anodot for our to receive funds for campaign. He is notified through email when we receive these donations. 2 of these donations were missed by him. And when he was doing his reconciliation with our checkbook and filing our D2 on April 15th, he noticed that these 2 donations were not reported on A1s in a timely manner. So at that point in time, he reached out to the State Board of Elections to try to understand what he needed to do to properly report, was given some guidance and did so. These 2 donations were filed timely on the D2 report for that quarter. And I just asked the board to take in consideration that we have had no prior misdoings, and all our filings since then have been timely and up to date.
Questions from the board members, please?
Question, are you currently in office or are you considering?
I'm the sheriff of McHenry County, yes, ma'am.
Then I don't have to ask the second question.
Mr. Nauman, do we have, Mr. Newman, do we have an accurate representation from the,
Madam Chair,
committee?
he is out of the room at the moment, speaking with another client.
How much does the committee have at this time?
Approximately $40,000, ma'am.
You've probably heard us say before, and unfortunately you'd have to say it again like a broken record. We don't have statutory basis to grant your appeal,
I understand.
unfortunately. So I think, again, as I said to the two previous, your discretion is gonna come in the settlement offer. So I would make a motion to accept the recommendation of the general counsels and deny the appeal.
I
second.
Roll call, please, Mrs. Calvin.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Thank you for your time, guys. Yeah, I'll wait.
Mr.
for him to
Nauman's
do that.
up there.
Appreciate you guys.
Could you, Madam General Counsel, could you clarify, because this is Sheriff Tillman's first offense, does the stay apply to him, to this committee?
There were two offenses, so
Oh,
no.
okay.
I thought the same thing.
Okay.
Madam General Counsel?
Thank you, Madam Chair. Give me one moment, please. Is there anyone else present either in Springfield or Chicago on any of the other appeals before the board today?
No, Madam Chair, General Counsel.
Thank you. In that case, there is one case I'd like to call separately because I was able to find a way to grant that appeal in part. So right now I'll call agenda item 2A13. It's SBE versus Friends to elect Jennifer Maddox, 24 MQ 89. It's a little complicated, so I'm just going to read my full recommendation. The committee is appealing a $400 civil penalty for the 16-day late filing of the March 2024 quarterly report. The committee also has a previously stayed penalty of $250 for a total of $650. The committee tries to invoke an electronic filing defense, explaining it encountered an error message when trying to file the report in IDIS and contacted board staff on April 16th, the day after the deadline to sort out the issue. However, the committee did not actually file the report until weeks later on May 7th. Rule 100.150C5D provides that after seeking staff assistance for an electronic filing issue, quote, following this contact, the committee must make a reasonable attempt to resolve the issue and file the report as quickly as possible, unquote. Although the rule does not define as quickly as possible, waiting until May 7th to correct an electronic issue resolved on April 16th does not seem to me to be as quickly as possible. Therefore, the hearing officer recommends, and I agree, that the appeal should be denied because the electronic filing defense is inapplicable and $650 would be owed. I just wanted to point out, I'm sorry, I just read a recommendation. Well, we could certainly vote on this case, but it's a different case where I recommend changing the outcome. So I apologize for that. But I recommend read the recommendation on this, which is to deny the appeal on 2A13.
Your motion? Or are there any questions? Are there any questions?
Confused. Hold on. I'm confused. So we're on doing 13?
We're doing 13 and I should have done a different one, but I called 13. So here we are.
I see.
So let's deny it.
We're not, you're
My mistake.
about this one to grant.
My mistake.
No one is here on this?
No.
No one is here on any of the other
I move to
appeals.
accept the recommendations of the general counsel.
There you go.
Second?
Roll call, Mrs. Calvin.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Thank you, Mrs. Calvin. Madam General Counsel, from my, records, we now have 8, 9, 10, 11, 12, and 14 remaining. Is that correct?
19 and 20.
I need to check something in my notes. Is there a way that we could take a 5-minute break before we conclude this so that I can iron out whatever error I made here?
I have no objection. Anyone have any objection to 5 minutes? It's now
No, ma'am.
10:59. Will motion to recess for 5 minutes?
Yes. I mean, we're in recess for 5.
Thank you.
If everybody would mute for a recess, that would be great.
Are we all back?
Yes, we are all back in attendance.
So, is Madam General Counsel back?
I am, and I have sorted out that I was supposed to call agenda item 2A14. So if I could do that right now. SBE versus Rolowitz for ETHS 24 MQ 91. The committee is appealing an $800 civil penalty assessment for the 16-day late filing of the March 2024 quarterly report. The committee's affidavit said the committee is small and has insufficient funds to pay. The committee requested a hearing but did not appear. Here, I agree with the hearing officer's recommendation to deny the appeal for lack of an adequate defense. However, I would correct the final paragraph to show that $800 is due, not $960, as the committee's previous fines were paid. So we're denying the appeal, but making it clear that $800 is due.
Is there a motion?
I would move we accept the recommendations of the general counsel and an $800 fine be assessed.
Second.
Roll call, please, Mrs. Calvin.
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Turbin?
Yeah.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
So, Madam General Counsel, we have 8, 9, 10, 11, 12, and 19 and 20. Is that correct?
I actually have one more case I'd like to read to you that there is a correction required to the hearing officer report. And then hopefully after that, we can make a group motion on the remaining cases.
Please proceed.
Thank you. If I could call agenda item 2A9, SBE versus Friends to elect Patty Guston, 24 JQ 32. Here, the committee is appealing a $150 civil penalty assessment for the 3-day late filing of the June 2024 quarterly report. The assessment letter also lists a previously stated fine of $50 for an A1 violation during the second quarter of 2022 for a total of $200. The committee says the IDAS system was down, resulting in the late filing, but the hearing officer points out that there were no IDAS outages during this time period. Here, I recommend supplementing the hearing officer's recommendation by noting that in order to qualify for an electronic filing defense under Rule 100.150C5, the committee must have contacted the board for assistance with the filing problem, and here there's no evidence that the committee did so. However, while I agree with the hearing officer that the previously stated $50 civil penalty expired, it expired after 2 years, but as a result of this expiration, the civil penalty for the late filing of the June 2024 quarterly report should have been calculated as a first offense rather than a second offense. So here, my recommendation is that the appeal should be granted in part, that the penalty be reassessed as a first penalty and not the second, making the total due only $60. The remainder of the appeal should be denied, as the committee has not qualified for an electronic filing defense, and the $60 penalty may be stayed as a first offense.
Questions? Motion.
I would move we accept the recommendations previously stated by our general counsel for 2A, what's the number? 9.
There's second.
Second.
Roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Yes. Ms. McCrory?
Yes.
Mr. Turbin?
Yeah.
Mr. Brett?
Yes.
Vice Chair Donahue?
Yes.
Chair Watson?
Yes.
Motion passes.
Thank you, Mrs. Calvin. Is there anything else before the group motion, Madam General Counsel?
That is it. Thank you for your patience and the recommendation on agenda items 2A8, 10, 11, 12, 18, and 9, excuse me, not 18, 19 and 20. So let me do that over again. 8, 10, 11, 12, 19, and 20 is to deny the appeals.
Is there a motion, please?
So moved.
Second.
Roll call, Mrs. Calvin.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Turbin.
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Thank you, Mrs. Calvin.
You're welcome.
Other campaign disclosure items, Madam General Counsel?
Thank you, Madam Chair. We will need a motion to approve the assessments and issue the board orders issued on pages 158 through 166. I would note, however, that because the board just accepted the settlement offer on agenda item 2A3, Jenna DeYoung for city clerk can be deleted from this list of assessments and board orders. So is there a motion to approve the list of assessment and board orders excluding the Jenna DeYoung for city clerk committee?
So moved.
So moved.
Second.
Roll call, please.
Ms. Ballard Croft, Ms. Ballard Croft. Ms. Craig.
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Present.
Motion passes.
Thank you, Mrs. Calvin. Is there anything further, Madam General Counsel?
The payment of civil penalty assessments memo is informational. Before we move into the complaint following closed preliminary hearing, I'm noticing that there is no one present on that case in Chicago. It's 2A23 Blahanka versus Grum for Lake County. Is there anyone present in Springfield on that case?
No, ma'am.
In that case, the board could consider dismissing the complaint for want of prosecution. Alternatively, the board could recess to executive session to hear the case.
I would move that we take your recommendation, Madam General Counsel.
I move that we dismiss the case for want of prosecution.
I second.
Roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue.
Yes.
Chair Watson.
Yes.
Motion passes.
Thing is, we did not go into executive session. We don't need to come out of executive session, and we don't need to vote on any board action. So we are now at consideration of proposed amendment rules regarding business entity registration for procurement. Is that correct, Madam General Counsel?
That is correct, Madam Chair, and Executive Director Matthews is going to tee up this issue for us today.
Thank you.
All right, good morning, everyone. This was a joint executive proposal along with legal and the campaign disclosure division. So I agreed that I would summarize and just bring it to you for discussion and consideration today. The
Would you keep
business
your
entity-
voice up, please, Madam
Yeah.
Executive Director?
Yeah, I was just handed the mic. So the business entity registration for procurement, or commonly referred to as BREP within the agency. This proposal is being presented to you today in an attempt to take necessary steps to cure a repeat audit finding related to the statutory requirements in section 9-35 of the election code to monitor whether business entities are updating registration information as required. Staff within the campaign disclosure, legal, and executive divisions have conferred and present this rulemaking for board approval. The proposal makes necessary changes to existing sections 100.180 and 100.185 of our administrative rules. These recommended changes will clarify what constitutes a violation of the registration requirements, establishes a complaint and hearing process for potential violations, and also provides the board discretion to impose a penalty for actual violations. Tom Newman's memo has been provided to summarize the matter and the proposed rulemaking. I'll note that the proposed rulemaking is meant to work in conjunction with the previously approved legislative agenda that the board recently passed that enables staff to seek clarification and/or changes to statutory language to better define in statutory provisions our role as a ministerial agency. It's the hope that this combined approach will satisfy statutory requirements to the result of finding no future audit findings on this repeat issue. Staff from Campaign Disclosure and Legal are available if the board has any questions or would like to discuss further. But before turning it over to you, I just wanted to thank Tom Newman, Brian Pryor, Heidi Poyer, and Jordan Andrew. They worked several months to make the proposal happen and to bring it to you. And just an additional note is that the next audit cycle will begin this spring. So the hope is to get it approved today. We are ready to file the rulemaking and start this implementation process as soon as possible, so that when the next audit occurs this spring, we will have on the books this type of procedure in process to, again, hopefully prevent a future audit. So thank you. I'll turn it over to them now.
Who are we turning it over to?
Also to the board for any questions or if there's further discussion on it. If at any point the board would so move to approve it as well, that is what staff is seeking today, but we're happy to discuss prior to that.
Do any board members? Yes, Member McQuarrie.
So just for curiosity's sake, or for education's sake, I should say, what's the procedure from here? Let's say we say to you, yes, we approve the changes, and then does it have to be approved by anybody else? Is it just implemented? What?
So our first step for the proposed rulemaking is that we would submit it to JCAR. So JCAR would then review it. They might come back with edits. They might come back with a question as to whether we have the authority to do this. So that would be our first step. And then within JCAR, there's several requirements. There's posting requirements, notice to the public that we're moving forward with this. And it's a lengthy process in and of itself, but it would also be done with the approval of JCAR. As it's proceeding through JCAR internally, though, we would hope that it would pass JCAR. And so we would move forward with beginning the implementation of creating this type of process for the agency.
Thank you.
Any other questions from members of the board? Seeing none, is there a motion to accept the proposed amended rules regarding the business entity registration for procurement?
So moved.
Did we get the first and the second?
Yes.
Roll call, please, Mrs. Calvin.
Ms. Bella Croft,
Yes.
Ms. Cray,
Yes.
Mr. Nevesi,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson,
Yes,
motion passes.
thank you, Mrs. Calvin. Madam Executive Director, your report is next on our agenda.
Okay, thank you. The first item for my report is the certification of the April 1st, 2025 consolidated election ballot. So this is a certification of those candidates that filed with the State Board of Elections. I have a list of those candidates to be certified to the April 1st, 2025 consolidated election ballot. It's prepared, it's available should any board member want to review here in Chicago. It's also available in Springfield. So with regard to the certification of this ballot, staff are seeking a board motion to certify the ballot and to also authorize staff to issue amended certifications as appropriate in the event of any candidate withdrawals. And this would be subject to confirmation that affected election authorities could implement the withdrawals without incurring burdensome reprinting and reprogramming costs.
Any question from board members?
Just a quick question, the case that we did earlier, that I believe was subject to this, I just want to make sure that voting on this would not, I don't know how that case was resolved in settlement.
Yeah, I believe that the candidates in the cases earlier are not subject to our certification at this point, but the other election authorities would certify and then to us. Typically, we would notify them if there is a candidate that has outstanding fines, and they'd be subject to the ballot forfeiture there. But we will make sure that if there's any candidates that are subject to ballot forfeiture, if it is necessary for this list, or also for those other election authorities, that there would be that notification, their names would be removed if they have not paid those fines timely.
Thank you.
Any other questions? Mr. Vrett? Are you okay?
Yes,
Okay.
no questions. Thank you, Madam Chair.
Then is there a motion to certify the April 1st, 2025 election ballot? I'm sorry, I didn't hear a motion or a second.
I would move.
Oh,
Sorry.
I'll get it. I get it.
Our mic was off. I move that we accept the certification of the ballot.
Second.
Roll call, please, Mrs. Calvin.
Ms. Ballarcroft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Turbin,
Yes.
Mr. Brett,
Yes.
Vice Chair Donahue,
Yes.
Chair Watson.
Yes.
Motion passes.
Okay, thank you. The next item is just an informational item. It's a listing of the 19 jurisdictions that will be holding a consolidated primary election on February 25th, 2025. So the list of those jurisdictions is included on page 192 of the board packet.
So that's informational, is that correct?
Yes, it is.
You may proceed, Madam Executive Director.
All right, and next is just a brief legislative update, being that session has only recently started. The spring session calendars are provided to you for your information. SB staff are monitoring bills as proposed. There are several election bills right now, but they're not formal yet. So we will monitor those as we do every session. And as issues arise or we notice that there is something that would potentially impact the agency's operations or election administration, we will notify the legislative subcommittee, but that will take some time over the next several weeks, if not months, to identify which of those bills are actual and could have an impact. As for the agency's legislative agenda, Senior Policy Advisor Brian Pryor advised that he is seeking formal sponsorship of our bills. And as soon as we do know who those sponsors are, we will notify the board. But other than that, right now, we're just monitoring what's going on. Brian is present at the Capitol near daily. And I also suspect that over the next few weeks, we will receive requests from staff at the General Assembly or sponsors of bills to have us analyze any that would have an impact on elections. And we will do that from a purely operational standpoint without making any sort of policy judgments on it. But that will really be the business of the legislative session at this point.
C, D, E, and F appear to be informational. Is that correct, Madam Executive Director?
Yes, C, D, E, and F are all informational, but if any board members have any questions, we're happy to address them. No board action is necessary on those items, though.
Any questions from members of the board? Is there anything else with respect to your report, Madam Executive Director?
There's nothing else. Thank you.
Number 4 is other business. Do we have any other business at this time? Number 5 is comments from the general public. Do we have any general public listed for comments at this time?
No, ma'am.
Number 6, is there a motion to move into executive session for the purpose of discussing the appointment, employment, compensation, performance, or dismissal of specific employees, as well as the minutes of the November 19th and December 2nd executive session meetings pursuant to section 2C1, 2C11, and 2C21 of the Open Meetings Act.
Chair, if I could interject quickly, I believe pending litigation is also to be discussed.
You're correct. Pending litigation is also included pursuant to the aforementioned sections. Do I have a motion to move into executive session?
So moved.
Second?
Roll call, please, Mrs. Calvin.
Ms. Bellicroft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese.
Yes.
Ms. McQuarrie,
Yes.
Mr. Turbin,
Yeah.
Mr. Brett,
Yes.
Vice Chair Donahue.
Yes.
Chair Watson,
Yes.
motion passes.
Thank you, Ms.